everyone. So nice to see you all again. It's nice to be to LinkedIn again and see you all. Please write in the chat if you are listening to us, if you are watching this webinar as well, so we can greet you and meet you properly. And we will introduce just a little bit later, but first thing now is we are talking about the CCPA, we are talking about the GDPR usually, but today we are talking about the CCPA and about other Californian and European and American rights, Northern American, I mean in general, it includes Canada and the US as well. And we see that the new year is coming and we have to get there prepared. And of course, we have to get there prepared with our data protection compliance program. And today we are talking about how to prepare. Right, Julia?
Yes, and in particular, we're going, as Kate said, talk about Canada and the USA. The Kate will provide you with information about the California privacy law, and in particular, what changes are going to be in 2023. And I, in turn, going to talk about the federal legislation of the United States and also about other state privacy laws. And in the end, we're going to talk a little bit about the Canada and the proposed Bill 27C. Just as usual, that's our Catherine and the head of privacy department. And my name is Yulia. I'm a junior privacy lawyer at Legal IT Group. And we're also gonna, as I have already said, that's our agenda basically: CCPA, CPRA, federal laws, state privacy laws, and the PPD reform in the Canada, which deals with the proposed Bill 27C. The Kate will start today, and she is gonna tell information about how CCPA affects the company.
We will start with California, of course, because California has one of the most stringent frameworks applied across the US. And we will start with California because it's the obvious thing to do, because everyone who is starting a new business and is targeting American market tries to figure out how to comply with the CCPA at first, because, well, it is one of the omnibus laws that actually covers all aspects of data processing and is not focused on some, for example, section of economy or some market specifically, such as healthcare services. And well, CCPA is a California Consumer Protection Act. It's a state law. It's not a federal law, but a state law, meaning that it applies only in California. But as it is usual among the data protection laws, it actually targets more than just the California market players. It affects everyone who is doing business in California, who is working with Californians, or sells data of Californians. So as you map your data that you are using for your business, and in case you see that there are something that comes from California, be sure to check whether you are eligible to apply the California Consumer Protection Act. And we will start with a little bit of chronology. We will start with the right to privacy, which is not covered in the American Constitution. And if you will open the book and will read through the articles, you want to find the separate right to privacy among the rights granted by the Constitution in comparison to some later constitutions, for example, like European ones. Whereas the right to privacy is usually separated in a special clause or as a part of some other right, just as right to confidentiality, for example. You will find the right to privacy in Californian Constitution. As you will know, the US legal system consists of at least two layers. One of the federal constitution, which is covering all the states and is applied in the US in general. And of course, each state has its own constitution and acts in compliance with it. And in 1972, the right to privacy was enshrined in the Californian Constitution. And here starts the official history of privacy in California, for example. We will then flash forward to 2017, and we have famous Californian who initiated the adoption of the law on personal data protection. And later, in 2018, the bill, not the one proposed by the All-Star, but another one, was actually signed into the law. And it enters into force lately in November, and of course in January, starting from January the 1st of 2020, we start to apply it to our own company's activities that concern personal data or personal information, as mentioned in the CCPA. And this year, it is the last year the CCPA actually applies, and now starting from the January 1st of 2023, we are starting to apply the CPRA, and we'll talk about it later on the next slide. Hey, yeah. So we will start with the person who is protected by this act, of course. As any lawyer will say, we will start from the root of the problem. And in this case, the consumer is in the center of protection. Consumer is defined as a natural person who is a Californian resident. It's important. However identified, including by any unique identifier. So if you have any personal information that can help you understand who is talking to you or who is working with you or who your client is, you can identify that this person, well, actually exists. It's a real person. And therefore, you have to apply the CCPA to this person. So we will start with consumer is not only because it buys goods or services. It can be anyone. It can be a tenant, it can be a student, it can be an employee, for example. It can be anyone. So despite recognized stereotypes, it's a consumer has to enter into some market agreements with you, for example, buy some service from you or buy some goods from you. It doesn't mean that the consumer is only this person. Actually, anyone who is, a California resident and whose personal information is stored in your system is eligible to be, considered a consumer, and this requires protection under the CCPA standard. And CCPA protects personal information. This is the root of the problem, actually, because personal information, just like the personal data in the GDPR European standard, as you know, it's an information about specific person or household. And it's important because the GDPR, for example, the European standard doesn't call the household. It only concerns the individual legal person. But the CCPA mentions a household as one of the points of attention. If, for example, if you have one computer in your household and it can be used by any member of your family, still, despite the fact that you cannot sometimes single out what activities, for example, browse history belongs to a specific person, but you can usually do. But sometimes you cannot say who is using the computer right now, but still the information that is stored in this computer is protected by the CCPA, and it's important. Accepted as an exception from the personal information that helps you to identify the California resident. Let's remember about the unique identifier is that aggregated data means statistics. The identified means that you have some information about some abstract person, but you cannot say who precisely it is. Publicly available data, such as data from federal registers, for example, and of course, data protected by federal law, because we have some other legal frameworks, and Yulia will tell you a little bit more about them later. And if there is a special law for this, for example, for healthcare information that is protected by the federal law, then we won't apply the CCPA. It's remember to understand. So please check if you're working in finances, for example, if you're working with children for processing children's data or providing services to children. If you're working in the healthcare sector, you have to check whether you are eligible under some other privacy laws, and it's important. But the CCPA applies to businesses. It means CCPA defines some different roles in data processing. Those are for business, meaning a company who decides which personal information is to be processed, for which purposes and by which methods. It's important to remember. And of course, this company, for example, company, entity, legal entity, some maybe an entrepreneur, and so on, vice versa, and so on and so on. This person has to do business in California. Well, it's a little bit complicated because there is no definition of doing business in California in the CCPA. So you'll have to check other laws and other precedents and legal cases in the California to understand what is considered doing business in California. But usually it's paying taxes and, for example, selling to Californian residents, just for starters. The entity has to do that for commercial purposes. If you're working with a non-commercial entity, you will have to recheck whether there are some other requirements mentioned in the CCPA. So some of non-commercial entities are covered by the CCPA as well. And of course, finally, at least one of 3 thresholds mentioned on the slide has to be actually satisfied. For example, the business have to have annual gross revenues $25 million. It has to either buy or receive for business commercial purposes, it's important, sell or share personal information of at least 50,000 residents of the state of California, their households or devices. It's important to remember as well, because sometimes we are focusing on individuals, but we skip the information that we're actually using the information about their device. And sometimes this device can be used for 2 people or 3 people, even with the whole family. But still, this area is protected by the right to privacy. It's important to remember. And finally, business may have at least 50% of revenues from the sale of personal information of residents of the state of California. Because again, if you're doing business in California and you're selling information about the Californians, then you are likely to do business in California, and you have to, apply the CCPA as your framework in your business. Right. Next slide. So where to start with the compliance process? Let's mention that you are not thinking about this while you're starting your business, but as of now, you understand that you want to conquer the American market, for example, or if you want to start a new business in California specifically, you have to start somewhere, right? And what are the challenges of working with a CCPA in comparison to some other data protection laws in other countries and states? First of all, a CCPA is not the only law that deals with privacy in California. You'll have at least 30 other data protection laws that you have to monitor, that you have to analyze, and maybe apply in your business as well. And of course, there is federal legislation, because sometimes you have to consider, for example, providing the service to people under 13, mostly, for example, if you're working with social networks and you are creating one, so you understand that you may have audience that consists of minors, meaning people under 13. And then you have to, comply with COPPA, for example. And Yulia will tell you a little bit more about that. Another challenge is, in case of collision between the CCPA and another law, you have this ambiguous threshold that provides the law that provides the highest level of protection to consumer will prevail. So you have to understand which law actually is providing the highest level of protection. What does this highest level of protection include, for example, how we can understand it, which kind of protection we have to rely on. Is it a monetary compensation, for example, or maybe it's a more prohibiting law that must be applied? We don't know. There is no precedent to understand and show you clearly that this law has to be actually applied in this case. There was an interpretation. We are waiting for some other maybe CCPA regulations to understand how to apply, for example, this collision rule. Another challenge is that courts may apply different criteria to determine whether the company is subject to law or a state of California. Again, doing business in California.
One second, sorry, we have some troubles, but as far as I see, we already have the slide the Kate has been talking about.
Let's proceed. We don't have the definitions of doing business in the text of the CCPA. We don't have the definition of the territory. We don't understand whether this remembers that you have to comply with the CCPA if you are having at least $25 million per year. And is this revenue is generated in California, within the California state, or for example, worldwide, your annual overall turnover? We don't know. We have to apply different criteria, and courts may decide on, well, in different context and provide different resolutions and decisions. And there is, of course, this challenge because it's unpredictable what we will tell the court and what will court answer us in their turn. Later, another challenge is if a company acts both as a business and as a service provider, it has to tread carefully because sometimes some of the data it processes will be processed as a business, meaning they decide on the purposes and methods of processing data, and of course they are regarded as business. But another, for example, another product is marketed and provided to clients as a service provider of the product because they only provide, for example, some infrastructure or some software, and their client decides on purposes and methods of processing data. And you have to address different obligations imposed on both business, company as a business, and company as a service provider, and understand that every processing activity that concerns the personal information in California is provided to the client by the company acting as who? A business or a service provider, and which kind of protections used in every case, because, well, business and service providers have different obligations imposed on them, and at any time of at any moment of processing operation, at any processing operation that is used by the company must understand how to comply with the CCPA in this case, of course. And finally, if you are working under the brand of a group of companies, you have to comply with the CCPA if one of your other companies have to. For example, if you have your mother company that is working and operating under the CCPA, and you are sharing with a brand with this company, you use it to market your services, for example, you have to apply the CCPA as well, and it's important to remember and understand. Next slide. So we will talk about the CPRA, meaning California Consumer Rights Protection Act. It will enter into force on January the 1st, 2023, meaning it is the same CCPA mentioned in the California Civil Code, but some of its articles will be replaced by the updated ones. If you are going to start your compliance path right now and you will go to the site of California Civil Code, you will see that some of the articles, some of the sections are actually copied. You have two copies of the same article saying a slightly different things. And the second one is usually the CPRA that is coming into force. CPRA provides a greater control over personal information provided to the consumers, meaning that they have the right to correct their data, not only to delete, for example, or to access and see whether their data is processed, but correct the inaccurate data. If somebody is spelling my name, or maybe I've changed my surname and family name, and I want the company to address me in a proper manner because I'm not Miss Smith, but for example, Miss Ivanova, for example. I want to request that, the business would address me properly and to use my new name, for example, in this way. To limit the disclosure of sensitive information, because the CCPA does not contain the definition of sensitive information. To protect your sensitive information, you have to go to another law, for example, and apply it. But now CPRA includes the definition sensitive information and some other obligations imposed on businesses in relation to it. Now in the CPRA. So you can use the CPRA as a direct source of regulation in this regard. There are new rights regarding the profiling and automated decision making because CCPA didn't have one. There is a right for a private action. It's important because before CCPA only granted the right to go to the court to sue only in case of security reasons. Right now, a CPRA provides you a wider array of protection, not only by referring to the Attorney General, for example, but trying to sue yourself to get a greater control over the process. CPRA provides the differences between the sale and share of personal data because in CCPA it was a challenge to understand whether this processing where you provide some personal information to another company is a sale or a share, because one of them is used for, well, a business purpose in general, and another one is conducted for a monetary compensation, for example, or some other compensation that will actually be considered a sale. Now CPRA provides, well, clear distinction between the two, so you can understand whether you are sharing or selling personal data. Because again, if you are selling personal information, you have to comply with a greater array of obligations, because individuals have the right to request for their data not to be sold. And the minors have to opt into the sale of their data. You have to post a special link on your website that could help the individuals will ask you not to sell their data again, and so on and so on. There are many obligations that are linked to this sale process. And in case you are selling the data, you have to comply with them all. CPRA introduces new responsibilities the business do under the GDPR and have to comply with. For example, you have to review your contracts with your sub-processors to understand whether all the limits and all the obligations are written in them. Because if CCPA was rather advising you to enter into agreements with your service provider and your contractors and other third parties, CPRA requires you to do so. If you are using a service provider in your business, you have to sign a service agreement with them. It's important. And finally, we have a new regulator, because those who works and live in Europe and has an experience of working and living in Europe, they know that Convention 108 of Council of Europe was adopted in 1981. A long time ago, as you can see, and this convention required every member state to establish and provide necessary resources for data protection authorities acting as regulators in this area, so they could, interpret laws, that could provide some guidance, that could fines, that could provide investigations, and so on and so on. And the similar authority now works to enforce the CCPA and CPRA. And this is Consumer Privacy Protection Agency. Yulia will tell you a little bit about them later. So we will go to the next slide. So we will start with the CPPA, Consumer Privacy Protection Agency. What will we do? Why should we consider visiting their website for starters? Because they issue the guidelines and recommendations how to comply with the CCPA and CPRA, which will act as a body that ensures implementation of the CPRA. It can, again, carry out investigation, can fine, it can request to do something, it can provide some other sanctions, not only monetary, but for example, refer to the courts and ask for court settlement, and so on and so on. Consumer Privacy Protection Agency will act as an awareness center, because it will promote knowledge and trainings for privacy professionals, but not only for them, for service provider, for businesses, for consumers. It's important. So it will be working as a knowledge hub. It can appoint chief privacy auditors to audit compliance of the business in case there is a suspicion that you may be violating the CCPA. Then they can initiate the audit, or you may go to them and request your business to be audited, so you know that you are in compliance with the GDPR. And the Consumer Privacy Protection Act will be governed by a committee of 5 members. It's a government board. It's not only 5 members in the CPPA at all, but only 5 who are governing this agency. And interesting that the chairman of the committee and another member should be appointed by the state governor. So you have the Senate Rule Committee, you have the Speaker of the Assembly, you have the Attorney General whose votes are impacting the committee who is governing the CPPA. So we are preparing to and taking attention to the legislation as well. So the next slide. And we will go to the federal legislation.
Yes. Thank you, Kate, for the information about the California privacy laws, basically what we have now and what's going to become effective on January the 1st, 2023. And I'm going to continue with the United States. We are going to talk about federal legislation and some other state privacy laws. First of all, we need to say that there is no one specific law in the United States that protects personal data at a federal level. Instead, there are a lot of sources of legislation that either relate to specific subjects or, for example, specific types of personal data or specific industries. For instance, such acts are COPPA, Children Online Privacy Protection Act, or, for example, FERPA, Family Education Rights and Privacy Act, or, for example, HIPAA, Health Insurance Portability and Compatibility Act. Basically, there are more than 20 pieces of legislation at the federal level that in some provisions protect privacy matters of some individuals. And it's not very convenient to deal with a lot of pieces of legislation. So for a lot of time, it's been a debate to the need to create one single privacy and data protection law at the federal level. And in June 2022, actually, the American Data Privacy and Protection Act, which is a bill, was submitted to the Congress of the United States. It basically supposed to provide persons, residents of the United States, with the fundamental rights that are related to privacy and personal data, and also to create a necessary mechanism for to monitor how organizations comply with the provisions of such American Data Privacy and Protection Act. As of now, it has not yet been supported by the House of Representatives and the Senate. Yet, if it's going to be supported, then the main provisions would provide, for example, for some basic rights to access information, rights to correct information, rights to, for example, rights to delete personal information. The main provisions also would include a general prohibition for organizations to transfer personal data without the consent of some individual, or also impose a requirement to limit the collection, processing, and transfer of personal data by organizations to the extent reasonably necessary for the provisions for goods or services. So basically, we need to monitor how what's going on with this act, because as of now, its provisions may be changed, and maybe something will be have more protection, or will, for example, will have some other rights or other obligations of the businesses. Besides our federal legislation, we also have state laws. The GATE has given us information about the state of California, yet there are also 4 other states that actually adopted state privacy laws. As you can see on the slide, it's Virginia, Colorado, Connecticut, and Utah. Basically, all these acts are quite similar. They were all adopted in 2021, 2022, and will become effective in 2023, basically from like either January the 1st of 2023, if we are talking about Virginia Consumer Data Protection Act, or on December 31, if we're talking about Utah Consumer Privacy Act. In general, they, as I have already said, they are quite similar to each other and to the privacy law of the state of California, because they basically apply some requirements that says that they're applicable to businesses that do business in the respective state. For example, they provide goods and services, and they also have a threshold that are different for each privacy state privacy laws. For example, if you're talking about Virginia, then the organization should at least process personal data of 100,000 residents of the state of Virginia, or it should process personal data of at least 25,000 residents of the state and derive more than 50% of the gross revenue from the sale of personal data. So either 100,000 residents or either 25,000, but more than 50% of gross revenue should be from the sale of personal data. If we're speaking about the first one, Virginia Consumer Data Protection Act, it's basically the similar rights that are established under, for example, a CCPA, like the right to access the personal information, the right to erase, the right to modify personal information, the right to data portability, the right to refuse to process personal information, like for targeted advertising, and the right, for example, not to be discriminated against if a consumer exercise any of the rights that is provided in VCDPA. If unlike the California state privacy law, the Virginia Consumer Data Protection Act does not provide for a private right of action. It's enforced by the Virginia Attorney General, and if there is some violation, then the organization may have a fine. A fine can go up to $7,500 per violation. If you're speaking about the second one, the Colorado Privacy Act, then the similar thresholds apply. It applies to organizations that do business in the state, provide goods and services, and also either process personal data of at least 100,000 residents of the state, or receive revenue or discount on a price of goods and services from the sale of personal data if it processes data of 25,000 or more residents of the state. Unlike other privacy laws, the Colorado Privacy Act does not have a revenue threshold for sales of personal data. For example, it does not say, just like Virginia Consumer Data Protection Act, that, for example, 50% should be from 50% of the revenue should be from the sale of personal data. It just says that the organization should have some revenue or have such a discount. If the provisions of Colorado Privacy Act are violated, then it also maybe organization will also have a fine. A fine can go up $20,000 per violation. The Colorado Privacy Act also does not have a private right of action, and it's enforced by the Attorney General. The next one, the Connecticut Data Privacy Act, similar to the others, also applied to organizations that do business in the state of Connecticut, provide goods and services, and they have two thresholds. If either organization process personal information about 100,000 of residents of the state of Connecticut, excluding residents whose personal data is processed for the purpose of the payment transaction, or if the organization collects and processes information about 25,000 or more residents of the state of Connecticut and derives more than 25% of its gross revenue from the sale of personal data. In terms of this specific state privacy law, it's important to note that it excludes residents whose personal data is processed solely for the purpose of payment transaction from the all amount of residents whose information is supposed to be processed. So basically, if you have a business that, for example, does business in the state of Connecticut, but it solely process personal data of the residents for the purpose of payments, of processing payments, then it most likely such act will not apply to you. This exception is quite unique and is not included in other state privacy laws. The rights and the rights of the consumers are quite similar to the laws of other states. It basically says that they have right of access, right to modify data, right to erase data, right to refuse to process data for the personal advertising and marketing, and the right not to be discriminated in case if they exercise any of the rights that they have. The Connecticut Data Privacy Act also does not provide for a private right of action. It's enforced by the state attorney general, and if there is some violation, then the organization also may have have a fine, and the fine can go up to $5,000 per violation. The last one is the Utah Consumer Privacy Act. It applies to organizations that do business in the state of Utah and that produce goods and services to the residents of the state. That has also gross revenues, annual gross revenues of $25 million or more, and also controls or processes personal data of either 100,000 residents of the state or at least 25,000 of the residents of the state and derives more than 50% of the gross revenue from the sale of personal data. So it's quite complicated to know if your business is supposed to comply with the state laws, because it's important to note if you as a business process the needed amount of personal information about the residents of the respective state, or if the threshold of how much revenue should be obtained from the sale of personal data has been met. The similar rights also apply, the residents of the state of Utah have the right to know that their personal information is being processed. They have the right to access to such personal information, right to erase such information, or, for example, not to be discriminated. The same as the other state privacy laws, the Utah Consumer Privacy Act does not provide for a private right of action, and it's enforced by the Utah Attorney General. If, for example, there is some violation of the provisions of Utah Consumer Privacy Act, then the fine up to $7,500 per violation could be imposed. Moving forward, besides United States, we also have Canada. And in Canada, right now, there is ongoing PIPEDA reform, which basically is made by the so-called Bill 27C. That's a bill that was introduced in the House of Commons in June 2022, and basically like has like 3 acts in such bill. It has the Consumer Privacy Protection Act, or CPPA. It has the Personal Information and Data Protection Tribunal Act, and it has Artificial Intelligence and Data Act. If it's going to be supported, then it would repeal like the Part 1 of Personal Information Protection and Electronic Documents Act, also known as PIPEDA, and it's going to change its name to the Electronic Documents Act. As of now, such bill is at the second reading in the House of Commons. After it's going to be supported by the House of Commons, the Bill 27C should also be supported by the Senate. As of now, we're going to speak about some main changes that are proposed by the Bill 27C, the first act that's like basically included in Bill 27C. And the main one is like a Consumer Privacy Protection Act. The main changes that are proposed, they deal with the valid consent, the exceptions for obtaining such valid consent, some new rights, and new penalties and fines. We're going to start with the valid consent. The CPPA also states, just like PIPEDA, that the valid consent is basically the basis for the processing of personal information. Yet CPPA expands the definition of such valid consent. If we look in PIPEDA right now, we will see that we will see the provision that says that the consent is valid if the individual can reasonably expect to understand the nature, the purpose, and the consequences of the collection, use, or disclosure of personal information. Yet, if we look in the proposed changes of the CPPA, we're going to see that the consent is valid only if organization gives a lot more information to the person about the collection and use of such personal information. For example, the organization should provide information about the purposes of the collection, use, or disclosure of personal information, how the information is supposed to be collected, used, or disclosed, if there are any foreseeable consequences of such collection, use, or disclosure of personal information, and what are they. If it's possible, also the specific type of personal information that's supposed to be collected, used, or disclosed, and also the names of the third parties, or if it's not possible, the types of third parties to whom the organization may disclose personal information. So basically, in essence, the valid consent in PIPEDA as it is now and in proposed Bill 27C are similar, yet it's just more information that's supposed to be provided by the organization for the consent to be valid. Moving forward, we also have 2 new exceptions for obtaining consent. Just like PIPEDA, CPPA provides some exceptions when basically you do not need obtain a valid consent from the person to collect, use, or disclose their personal data. In general, they deal with, like, for example, public interest, if there are any investigations, if it's needed to disclose information to some public institutions, or, for example, if such processing is needed or required by law, and also if information is publicly available. In the essence, the exceptions stated in PIPEDA and exceptions stated in CPPA are similar. However, there are 2 new exceptions that are provided in the proposed bill. Basically, the first exception says that organization can collect, use personal information about some individual if it's needed for a so-called business purpose. Basically, it may be used if it meets 2 conditions. For example, the person should reasonably expect that his or her personal information is supposed to be collected or used for such business activity. And also, if this information that's supposed to be collected or used is not going to be used for the purpose of to influence the behavior or decisions of such individual. So this is a very useful exception for the businesses, and that's why they should at least have a glance to it to see if they can use such exceptions in the future, if the bill is going to be adopted. Beside this exception, the CPPA also establishes that organization can disclose personal information without the knowledge or without the consent if it's needed for public benefit purposes. For example, it can be purposes that relate to health safety, for protection of environment, but such information should be there identified and may be disclosed to only some types of organization. Basically, it's like state organizations that deal with such public benefit purposes. We also have a new right to erase personal information. So basically, a person can send a request to organization that says, please delete my personal information. And in turn, the organization should delete such information, yet this right is not like absolute. For example, in certain cases, organization may refuse to delete information if it's, for instance, is required to them by law to have such information. We also have new private right of action, yet this right of action is also quite limited. For example, the Bill 27C says that a person can have such private right of action, have a claim against the organization for damages or losses if a privacy commission has concluded that the organization breached the requirements of the CPPA, or if a newly founded tribunal also states that the organization has violated the requirements of the CPPA. Beside private right of action, we also have a right to data portability. Basically it says that organization upon the request of the person should disclose personal information about him or her to another organization that he or she chose. The also well-known that there are some fines and penalties for the violations of the such proposed law. If it's going to be adopted, then we have like two types of financial penalties and fines. If it's an administrative penalty, then it's going to be up to 10 million Canadian dollars for like specific violations of the provisions of CPPA. And beside administrative penalty, it also can be a fine up to 25 millions of Canadian dollars, or 5% of the organization gross global revenue. Also, in case in violation of certain specific provisions of the CPPA, and in case if organization like violate the requirements of the privacy commissioner. Yet it also should be noted that just because the bill has not yet been supported, these changes can also be somehow changed, and we may have like some other, for example, rights, or we have some other requirements that the organization should comply with. As I have already said, the Bill 27C basically consists of 3 acts beside the CPPA, which is gonna change the PPEDA. We also have a so-called Tribunal Act, and we have Act. The Tribunal Act basically should establish a personal information data protection tribunal, which is responsible, for example, for imposing before mentioned administrative penalty. In turn, the Artificial Intelligence Act should establish a number of requirements for the design, development, and the use of artificial intelligence system. That's all the main changes that are proposed by the Bill 27C. So we're going to see in the future what's going to happen and if it's going to be adopted. Just by what we have already said with Kate now, you can see that there are a lot of pieces of legislation that the company should comply with if it's gonna be in the North American market, just because all data privacy laws, well, in general, have can be imposed on organizations that are located beyond the country or the state in which they were adopted. Like, for example, the CCPA can be applicable to organizations that are in Europe, and the same goes with the other state privacy laws in the United States, or goes with the Canadian legislation. That's gonna be all in our today webinar, and we hope that we provided you with information, with important information about the new proposed changes to the legislation of the United States and Canada, and especially the changes to the that are going to be enforced in 2023 in the state of California and some other states.
Yes, that's actually all for today, we believe. So thank you for your attention. Thank you for being here with us. If you have any questions, if you want us to tell a little bit more about something that, well, that we have not yet covered, you can write us a letter. You see our email. And of course, should you have any questions, again, if you want us to tell a little bit more about other aspects of privacy laws, for example, in Europe, in Canada, in the US, if you want to discuss or maybe share some story with us, please feel free to write us using our email. We welcome any communication from you to us because, well, we love just talking to our listeners as well. And stay tuned for other webinars. We are looking forward to see you again with us, maybe as our guest, for example. So please stay tuned. Subscribe to our social media, for example, if you want to keep track of everything that we are posting about the privacy law. And see you next time. Stay safe.